Good evening, everyone. Welcome to the American Enterprise Institute. My name is William Haun. I'm a non-resident scholar here in the Center for Social, Cultural, and Constitutional Studies. It's my great pleasure to be discussing a brand new book tonight called The People's Justice, Clarence Thomas and the Constitutional Stories That Define Him, written by our esteemed guest this evening, Sixth Circuit Judge Amul Thapar. I thought it might be valuable to begin our discussion tonight first with a quote. The Constitution of the United States is not a mere lawyer's document. That quote is from Woodrow Wilson, not someone that you might think that Justice Thomas would agree with very often, but I suspect that by the time you put down the people's justice, you might think that Justice Thomas and the originalism he practices would have some common ground with President Wilson on that. And the fact that Judge Thapar has been able to show that kind of deep commitment in American thinking about the Constitution makes his book a very interesting and impressive achievement. Over the past 40 years, originalism, which is Justice Thomas's judicial philosophy, has become mainstream. And it's become mainstream predominantly as an interpretive theory. Yet through vivid personal vignettes, Judge Thapar has provided a perspective of originalism and Justice Thomas's application of it that is less philosophical and more practical. On Judge Thapar's telling of Justice Thomas's jurisprudence, originalism is not an abstraction. It's not an abstract theory. Rather, the core idea that the American people who adopted a given constitutional provision have the right to have their understanding of those words vindicated unless or until the American people change that understanding reflects a deep respect for the ordinary American. Originalism contains that kind of sympathy for the ordinary American, but it's not a sympathy defined by political ideology. It's a sympathy with how the law affects people's daily life by deeply understanding the principles and implications of a legal rule and how it applies over the long term, well beyond the demands of a moment that might lead a judge to change the meaning to what's fashionable. And Judge Thapar is in many ways an ideal advocate to articulate this approach of originalism tonight and through this book. He's the child of immigrants, and he's a graduate of Boston College and Berkeley Law School. And despite a legal career that's taken him from federal clerkships and prestigious law firm practice here in DC and Justice Department service, he's clearly learned much from his roots. For instance, his mom sold her successful restaurant after September 11th to become a social worker with the US Army to help special forces and other heroes transition home from the battlefield. And her son reasoned similarly in a story that I hope Judge Thapar might tell us about tonight. He made a vow to leave private practice and join the US Attorney's Office because he survived a plane flight on September 11th. On the Sixth Circuit, his jurisprudence and his interest in originalism show someone who is uniquely well qualified and suited to explore the depth and richness of Justice Thomas's opinions. So Judge Thapar, I'm so pleased to welcome you to AEI. We're very grateful to have you here and to discuss the people's justice. Thank you.
Well, thank you very much for having me. It's a pleasure to be here.
Yeah. Would you mind maybe starting a little bit about your own life story and maybe what in your life story kind of resonated with an interest in Justice Thomas's judicial philosophy and his approach?
Yeah, there's a lot there. So as you mentioned, I'm the child of immigrants. My dad came over. My dad grew up in a town called Ludhiana. It's north of New Delhi in India. And unfortunately, his dad passed away when he was 2 years old. And so he was raised by a single mother, one of 5 kids. When we talk about poor in America, it's nothing like what he went through. When I went back to see where he grew up, I was amazed and shocked. He was nonetheless proud of it, as he should be. Did not have things like running water, things we take for granted here. His mom saved almost every penny she had to buy him a one-way ticket and gave him $5 and said, basically, good luck. And he was 18 years old. He came over, worked 3 jobs, and went to college. And eventually got a degree in engineering and relocated to Detroit, Michigan, where he joined Ford Motor Company, and that's where my sister and I were born. He got married to my mom. We were born there, relocated to Toledo when he bought into a small business that he still works with to this day. And so as we were growing up, there was one really common thing my sister and I both vividly remember. Anytime we would complain, my dad would remind us of his own roots and say, this is the greatest country in the world. If you can't accomplish it here, you can't accomplish it anywhere. And so put your mind to it, work hard, roll up your sleeves, and anything is possible. I think one of the things that I vividly remember is being a young child and my dad getting naturalized and how proud he was of becoming an American citizen, and my mom subsequently becoming an American citizen. And it's quite remarkable in a country where I watched my parents become American citizens, I can now naturalize American citizens. And that's a reason that I take those ceremonies to high schools and do them in high schools instead of the confines of courtrooms. I think it's important for young people to see that they were given the gold card at birth by being born in this country. And I want them to appreciate what they have and what my dad, basically came across the world to get, the opportunity that America provided him. As a child of someone who has provided all those opportunities and myself provided the opportunities, I've been appointed by presidents 3 times and confirmed by the Senate, I feel very grateful to the American people, but for the grace of the American people, I would not be sitting where I am. And I think it's important I honor their will, and their will is reflected in the laws and the Constitution and the words in those documents. And to me, the best way to honor their will and honor the oath I took is to honor the Constitution and the laws and the original meaning of those documents.
Right, that's great. And this book is unique to me because I've seen a lot of defenses of originalism as a theory, as a way of restraining judges, as a way of authentically understanding words and kind of semantic syntax, a way of understanding history. But you're doing something very different here. You're kind of telling originalism from a story perspective, from the litigator's perspective. It's interesting, in a lot of these chapters, Justice Thomas kind of appears at the end. And a lot of the chapter is about what's going on getting to the case. And I'm wondering why you chose that approach.
When Justice Scalia passed, we sadly lost what I believed was the ultimate evangelist for originalism. And Justice Scalia could always, it's so great. And my friend Ed Whalen's put together some books with his speeches. I commend them to you. They're worth reading. I just think it's remarkable. I like listening to them better than even reading them because he has this remarkable way of delivering a speech and talking. And he used to say when he went into a room and told people he was an originalist, people would run out of the room like he was a bear. And I think it's changed a lot. I think that's thanks to Justice Scalia. And one thing he always said is we have a responsibility to fly the flag of originalism if we want society to buy into it, if we want people to buy into it. And I think a lot of people have done a good job in writing the theory of originalism up. There's many law reviews. There's a lot more thoughtful and intelligent professors that have engaged in both originalism and criticizing originalism, which I only think makes it stronger. I think when we get critiques of originalism and give them an honest review, we make it stronger. And so I think it's important we take the critiques seriously, and Justice Scalia always did, and subsequently Justice Thomas and the other justices and judges that have become originalists. The one thing I think the next step, in other words, the next responsibility is to take it to the American people. And I found the best way of taking it to the American people was to tell the stories of originalism. And so what I started out doing, this book was not originally, had nothing to do with Clarence Thomas. It was a book about originalism for lay people, but when I wrote the beginning of the book and gave it to my wife, some of you have heard me say, she almost threw up and she said, no one's gonna read this, it's boring. I think she read it because she's married to me, and so she had to read it. And well, maybe she didn't, but in any event, she told me that, and so I went back to the drawing board. But one thing I realized as I studied the cases, as I was trying to write a book that would take originalism to lay people, is how compelling the cases are, some of these cases from a litigant's perspective. And so I started to study that, and I saw another thing, that Justice Thomas is in many ways, now that Justice Scalia has sadly left us, the kind of ultimate originalist on the court. I wouldn't say the only originalist, I'd say the ultimate originalist, and the longest serving originalist. And so he has a body of work from which you can look, and as you noted, while he is the protagonist of originalism, what I found is the real heroes in these cases are the litigants and the people that bring the cases in so many ways. And I think we often forget their stories, and so I thought it was important to tell that and tell their stories.
Is there a favorite story you came across when putting the book together?
You know, they're like your children, you like them all, but I really enjoyed putting Kelo first. If I can recount Kelo just really quickly, I don't want to ruin the first chapter for all of you, but here I go, I'm going to. So Suzette Kelo is this remarkable woman. She was down on her luck. She was getting separated from her husband, and the book recounts that. And she's looking for a place to live, and she wants a view of the water. And so Suzette goes out, and she's a paramedic at the time, and the only thing she could afford was a inexpensive house in a beautiful blue-collar neighborhood that was very run down. So run down, the real estate agent was embarrassed to sell it to her, but she thought it was perfect. She had always dreamed of having a view of the water. And Suzette got this house and then took correspondence courses to become a nurse so she could afford to rehab it. And through blood, sweat, and tears, she learned how to rehab the house. She rehabbed the house. She turned it into her perfect house. So perfect that she painted it her favorite color, Odessa pink. And she put a sign on it that said the Kelo house. Well, Suzette was doing this, and at the time she was doing it, trouble was brewing in her neighborhood. Or maybe not trouble, but the city of New London and the state of Connecticut were trying to recruit the Pfizer Corporation, who I'm sure you all have heard of, to come into New London and take an old mill site. And Pfizer thought it was the perfect spot for them to develop what they believed was their wonder drug, Viagra. And so here they were coming in, but they thought, if we're going to put the money into New London, we want New London to have an upscale condo building, a health club, upscale restaurants and shops, and a park. And in order to do all this, they would have to take away this blue-collar neighborhood through a process known as eminent domain. And so the city of New London teamed up with the state and the NLDC, the National, I can't even remember the title, Development Corporation, New London Development Corporation. And what they did is they decided to take property by eminent domain. Now, as you all know, eminent domain is provided for in the Fifth Amendment. It says that the government may take your property for public use with just compensation. As Justice Thomas ultimately explains, what that meant at the founding was they could take a sliver of your property to widen the road. They could take a portion of your property to put in a sidewalk or railroad tracks or something the public would ultimately use. Well, Suzette and her neighbors weren't going to just give up their property. So they decided to fight. And they recruited and were lucky enough to get on board the Institute for Justice, a Washington, D.C. kind of public interest law firm. And so they decided to fight this. And the Darys, who lived next door to Suzette, their family had been there 100 years. They loved this neighborhood so much that when their kids got married, they would put a down payment on a house in the neighborhood. Well, as they fought this, they ran into a case called Berman, right here out of the District of Columbia. Berman was a case in the 1950s. And in Berman, the District of Columbia wanted to take what they called blighted property, an area in Washington, and turn it into apartments and restaurants and private development. And they wanted to take the property from individuals and give it to private developers. And it went all the way to the Supreme Court in the 50s, and the Supreme Court said, yes, because it's for a public purpose. Well, Justice Thomas points out how this change in words occurred from public use to public purpose. Well, this case gets up to the Supreme Court, and there's argument. And Justice Scalia asked the city's lawyer, he says to the city's lawyer, do you mean to tell me you can take from A and give to B if B pays more taxes? And the city's lawyer says, yes. And he says, let me get this straight. You can take from the poor and give to the rich because the rich pay more taxes? Again, the city's lawyer says yes. Well, this fight, obviously, at the Supreme Court, Suzette Kelo and her neighbors lose. And they lose in a 5-4 decision. Justice O'Connor writes the principal dissent for the chief, Justice Scalia and Justice Thomas. Then Justice Thomas also writes a dissent. And he advocates returning to the original meaning. Now, the Institute for Justice did not think they had 5 votes for returning to the original meaning, so they argued, and Justice O'Connor and the others believe this, including Justice Thomas, that a private purpose is not the same thing as a public purpose, meaning the Pfizer's purpose is not the same thing as a public purpose, so you don't even need to go back to public use and whether the public would be using it. Justice Thomas took up the invitation of, amongst other organizations, the NAACP, to return back to the original meaning. And he talked about how eminent domain historically in our country has been used to prey on poor and minority communities, and how the original meaning was meant to protect them from this exact type of taking. And he points out how in Burma, 97% of the 20-some thousand people that were displaced as a result of that eminent domain were black. And he re-quotes some of the abhorrent quotes that were made by public officials about eminent domain that I'll let you read the book to see in their brief and in his opinion. So to me, this captures a number of things. The unintended consequences sometimes of getting away from the original meaning. Who it often harms. Those that are the least powerful amongst us. And where it's used when they get away.
Yeah, thank you for that. That was his dissent in Kelo doesn't use the word cognoscenti, but that's an interesting word to come up twice in your book, both in his Zellman opinion and in Grutter. And it seems like it's connected to what he's saying about how the departure from original meaning worked in Kelo. Do you have any thoughts about what he means with that word and why that may lead him to question settled doctrines like he did in Kelo and elsewhere?
I think when he refers to the cognoscenti, he's talking about, in his mind, what he would call the elites, or those that think they know better than the American people. And so when we get away from the original meaning of the Constitution, he calls them the cognoscenti, those that tell us what's best for us. And so he talks about, in Grutter and Zellman, Zellman's a case out of Cleveland, Ohio. I won't go into details, but it's a fascinating case about the schools in Cleveland, Ohio. And there's many remarkable characters that I came across and individuals in studying the Zellman case and studying the background of the Zellman case. And what was most fascinating to me, and I got to tell you the story, I tell this repeatedly, of my favorite person I came across, maybe in the whole book. Her name was Fannie Lewis, and Fannie Lewis was this remarkable woman who grew up in the South and relocated to Cleveland, and she was herself a product of public schools, and she was the city council person for the highest crime ward. And before she was a city council person, she would criticize city council. Even when she was on city council, she would criticize them if she didn't think they were doing what was in the public's best interest. And so she got to know everyone in her high crime ward. And what they said about her is no one, she was the safest person walking the streets of Cleveland. Why? Because if you jumped Fannie Lewis, she would call your mother. She knew everyone. But Fannie Lewis became a champion for vouchers, not because she didn't love the public schools, she did, but because she saw generations of kids being left behind. And so she wanted to help the Cleveland parents in those communities have a chance for their children to succeed. And the voucher chapter, and Justice Thomas himself is a product of private Catholic schools. Even though his mother, who made $10 a week, could not afford to raise him and his brother, she gave them to their grandfather to raise in the segregated South. Their grandfather, with a third grade education, understood that education means emancipation, to quote Frederick Douglass. These words later come back. It's the title of the chapter. So he saved every penny he had to send a young Clarence and his brother to the local Catholic schools, where Justice Thomas attributes his K through 12 education and the nuns in those schools as being so important in his formative years, in his education, in his understanding, and having that opportunity. And you see all of that come back in the Zellman chapter when he's talking about vouchers. And he's talking about how we have to contort the Establishment Clause to find that a parent's choice to send their kids to Catholic schools or other religious schools could somehow be a violation of the Establishment Clause. But he quotes Frederick Douglass extensively there. And his view has always been, recently validated by the Supreme Court, that affirmative action is an unconstitutional Band-Aid on a much bigger problem, meaning the failing opportunity we give our young people. As he says, the promise of Brown is not fulfilled until our young people, those in inner cities in Appalachia, those in the South and the North, have the opportunity, the same opportunity as all kids, to go and get a high-quality education. And high quality to him meant K through 12. The other thing he recognized as growing up in the segregated South is he didn't need someone sitting next to him of a different color to succeed. That's why since the time he's been on the bench, he's been a champion of historically black colleges. Someone who's believed fervently in the ability of historically black colleges to educate our youth, because they pay, in his mind, particular attention that other schools cannot to things. And Xavier, as he pointed out recently, the historically black college is the most successful college in America in taking kids from the lower class and moving them to the middle class.
Yeah, the reliance on Frederick Douglass there is really interesting because obviously Frederick Douglass is not a judge. He's not a precedent. So it's not like even the Federalist Papers in a way. Or you see when he's defending historically black colleges, he relies on Booker T. Washington.
Yes.
You quote him in the chapter on Virginia versus Black, saying that in every culture, certain things acquire a meaning well beyond what outsiders could understand. And I'm wondering what, citing Frederick Douglass and Booker T. Washington and looking to culture and meaning and practice, do you see any tension with that, with the kind of, maybe it's a caricature of originalism where I'm just focused on the text and I'm just doing the kind of mechanical work of law and judging?
Yeah, I think when we think of the original meaning of the Constitution, we think of not only text but concepts. And so I think it's important to remember that. In other words, nowhere in the Constitution, you can search it for separation of powers, you're not going to find it. But we have 3 separate vesting clauses. And so we look at that and what it means, and that's where separation of powers comes from. And so when you talk about original public meaning, originalism, you're looking at the text to understand what the document meant. But it's the text and the concepts out of the document that give you the guidance in ruling on today's cases, applying those to your understanding of what it meant to today's cases is what allows you to do it.
Right, right. And just to focus a bit on the Virginia versus Black example, because that chapter, it's so interesting. So much of the chapter begins with the lawyer who has this, he wants to defend the KKK and the cross burning, not obviously because he agrees with the KKK or the cross burning, but because he has a very principled, very theory-based view of what the freedom of speech is and expression and how important that is. And then Justice Thomas, this is the one, he breaks the silence at oral argument and speaks. Do you want to talk about maybe the different perspectives in that chapter?
Yeah, so you have Barry Black, who is the Klansman that burns the cross, and you have David Baugh, who's this remarkable lawyer who I had the privilege of him appearing in front of me at one point. David Baugh is interestingly enough, he's the son of a Tuskegee airman. He has this remarkable background where he himself went to a historically black college and opposed the integration of the historically black college, I think, if I remember correctly. And David's a really smart lawyer, and he wanted to defend the principle he believed, and the quotes from him are great, they're included in the book, to the Klansmen, that he was willing to defend him, not because he agreed with him. In fact, he obviously strongly disagreed with the Klansmen, but because he believed in the principle of the First Amendment so strongly that even Barry Black could voice his views as abhorrent as they were. So I called it Three Men and a Cross because there were three very different views of this cross, right? Barry Black, for him, it was a symbol of hate. For David Baugh, it was the constitutional right of abhorrent speech, no matter how much we dislike it, that people had a right to voice it. And then you had Justice Thomas talking about the history of the Klan and the history of cross-burning in his separate writing alone. I think it was ultimately a 7-2 case where 7 said, no, this presumption is a violation of the First Amendment. Justice Scalia would have let the Virginia courts decide it. And Justice Thomas says, no, this has become such a symbol, basically, of hatred. And he traces the whole history of the Klan's cross burnings, that it's not protected by the First Amendment. And therefore, this presumption is fine. The presumption makes sense, that you could presume in some sense that it was done as a matter of intimidation when someone burns a cross. And he talks about the people he talks about a woman and her experience with a cross being burned in her yard and what it did to her and her family.
Yeah, it's interesting because the free speech area, which you've got, I think, another free speech case in the book, Brown versus Entertainment Merchants Association, does seem to present this issue a lot of, are we going to take this very, to call it, I think, favorable, to call it kind of charitably, a very principled view of what the freedom of speech is, or are we going to take maybe a more practical, practice-based view of what's happening? And do you think that Brown versus Entertainment Merchants presents that too, or?
I think Justice Thomas viewed that differently. So Brown's about violent video games and what happens. Can California ban people under 18 from buying a violent video game without their parents' permission? In Justice Thomas's mind, so for the majority, that was a case about free speech and the free speech of the video makers, the violent video games. For Justice Thomas, it was something very different. It was whether or not the video game makers had a right to speak to your children. And he, again, goes and talks about parental rights at the time of the founding and how it was a privilege or immunity, basically, of citizenship. And I'm kind of cherry picking now, but what he was talking about at its core is that parents had a right to stop people from speaking to their children. And all California was doing was enhancing parents' ability to do this.
Mm-hmm, mm-hmm. And in the course of kind of putting these chapters together, kind of talking about the experiences of the litigants, the experiences of the clients, when you called them up and said, I would like to talk to you about this book, just generally, what was their reaction?
It's one thing I realized is that, and maybe all of us should remember, is justice delayed is truly justice denied. And for these litigants, these cases were their life. Mm-hmm. And they remain their life. Talking to some of these people, they're remarkable people. They're remarkable individuals. And just when they were waiting, the stress they would go through and everything that was going on in their lives and talking it through with them. Kathy McKee talking about a very painful period of her life when she accused Bill Cosby of rape. And she was one of the women who did so. And she's this amazing woman that has accomplished amazing things in her life through some of the hardest circumstances imaginable. And all she wanted was her day in court to prove that Bill Cosby was lying about her, and she wasn't given that. And I think it's it's just when you talk to them and hear the passion in their voice, it's incredible, and how it still lives with them.
Who do you think, you mentioned when you initially put this book together, you called it originalism for lay people. If you're talking to a non-legal audience, what do you really hope, what like conventional wisdom stereotype of originalism do you hope gets punched through with this book?
I say that critics will often say originalism for simple hand favors corporation over consumers, the strong over the weak, the rich over the poor, the government over the individual. I actually think that that's just not true. Originalism favors getting the law right. In other words, originalism favors the original meaning. And sometimes, as I say in the introduction, that's usually about honoring the will of the people. And when you do that, it most often protects, not always, because as Justice Scalia said, if we like the result we always reach, we're not being a judge, we're being a politician. And I think that's right, and I think judges need to remember that. But it more often than not, when you honor the will of the people, it protects the individual from government. It protects the poor from predatory members of society. It protects consumers often from corporations. And it protects the weak, as the Kelo case showed, from the strong and the corporations. And so it's really interesting to me. I mean, we're not talking about the State Farm chapter, but there where Justice Scalia and Justice Thomas don't believe that the corporations have a substantive due process right to limit punitive damages. Yet that's not talked about very often. In BMW, a case I don't talk about in the book, but that is the State Farm's the case that comes after that, Justice Scalia writes this brilliant dissent in BMW talking about how it seems just completely made up that we're going to create a multiplier and say, well, corporations you can recover 9 times punitive damages from corporations, but not 12. And where is that in the Constitution? It's in the substantive due process clause. And as I note in the State Farm case, Justice Scalia has these great questions where he's saying, what's the right multiple? Where do you find it in the Constitution that 10 is too much, but 9 is enough? And so it's really interesting, and I hope to correct that misperception and kind of also correct some other misperceptions, that Justice Thomas, I believe, and this book shows it, but I think it's more than that, has a strong black voice. It's just different. It's a different black voice than we're used to hearing. And I think it's important that get out as well.
Yeah, I know you don't mention Missouri versus, or you mentioned Missouri versus Jenkins in the book. We don't have a chapter on it, but I mean, just maybe talk a little bit about his longstanding defense of historically black colleges.
Yeah, I mean, there again, he's referring to the cognoscenti, and he says it never ceases to amaze him, and I'm quoting him, I hope I don't butcher it, that people assume that anything that is predominantly black is inferior. And again, this is his voice coming through, and it's his championing that he's been doing since he got on the bench in a Mississippi nursing case, I can't remember the exact name, all the way to the recent Student for Fair Admissions, where he pointed out that 50% of all black doctors come from historically black colleges, where I think 40% of all black engineers come from historically black colleges, where a statistic that stunned me, 80% of all black judges come from historically black colleges. And so, but throughout his career, you can go all the way back to his first years on the bench, he's been championing historically black colleges, and yet none of that has really been out there or recounted.
Do you think, are there certain opinions you would point to as evidence that Justice Thomas has really made a mark on the court's jurisprudence in terms of like moving the court to care more about these kind of ordinary daily realities and originalism?
I don't know that I can point to one case or one area. I can say that, if you look all the way, I think one thing to remember, and then I would say Justice Scalia and Justice Thomas together have really impacted the judiciary and impacted the country by pushing textualism, which now is, when Justice Scalia started pushing textualism, we didn't, now everyone in the courts repeats, we always start first with the text. That didn't used to be true, and people forget that. I mean, the young people in the room don't even remember that this was a fight Justice Scalia had to take on. And now everyone, it's just, no one even thinks twice.
As Justice Kagan said, we're all originalists.
Yeah. And so it's pretty remarkable where they've gone. But I want to point, if people say, well, Justice Scalia and Ed Meese and Robert Bork and these guys created originalism. No. If you go back and read Brutus, he talks about the original public meaning. He talks about that was the judge's responsibility. And Hamilton agrees with it, that the judge's responsibility is to interpret the terms in the document. And so Justice Scalia and Ed Meese and Robert Bork and others were just reviving what had happened. And if you look at old cases, they are very originalist in flavor.
Yeah.
And so this is something that got out of favor for a while, but is, I think, coming back. And it has a long historical pedigree.
Yeah, and that definitely seems like a joint achievement for Justice Scalia and Justice Thomas. And you mentioned a couple spots in the book where maybe they're methodologically aligned but reach different results. And Raich is an example, which you have a chapter on in the book. And there's some other ones outside. I can think of like McIntyre versus Ohio and anonymous political speech, for example. How would you, in general, kind of describe maybe there are different approaches to originalism?
Yeah, I talked about this a little bit. I talked about it before. I've talked about it. I think it's really, really important. When originalists or others attack Justice Scalia, I have a real problem with it because they will be doing this. It's just going to keep happening. You have to remember where he was at and what he has done for originalists. I would not be an originalist today if it wasn't for Justice Scalia. And I think Justice Scalia and Justice Thomas, in most instances, people say, oh, they always voted together. And I think that's not true because they had an understanding of what sources they could look at, right? And so Justice Scalia was more, I think, confined in the sources he would look to. Why? Because he was afraid of making, I think properly so, of making a mistake. He really believed, he had this saying that I love. He said, I'd rather, in the important issues of today, if the Constitution doesn't speak to it, I'd rather have 9 people randomly chosen out of the phone book decide the case than the 9 people in this building. Decide basically what's important for society. What that's saying is he trusted living majorities. He trusted the American people in passing laws. People say, well, if they don't find it in the Constitution, we have to amend it. That's simply not true. Title VII is not an amendment to the Constitution. It's something passed by our legislature and signed into law by the president. But I do think they would look to different things. I think McIntyre is one of the best examples of that, where Justice Scalia was looking at a lot of subsequent history, what happened right after the Constitution was enacted with regards to anonymous speech. And Justice Thomas was kind of looking more to tradition, what had happened before the Federalists and Anti-Federalists were anonymous. So it had to be. And I think it's a fascinating debate. I think it's a hard debate to say who's right. But it's really interesting. And the greatest thing about originalism, in my mind, is you have to show your work. You have to put it down for all to see, and then people can pick it apart, as they will often do. And I don't think that's bad. I think sometimes people are like, whoa, they're attacking so-and-so. They're attacking me. And no, I think it's healthy for people to look at what I did, critique it, because that's how I can get better.
And that point about maybe the use of tradition as an interpretive supplement for originalism, definitely a live issue, it seems. And Justice Thomas in Bruin kind of lays out a Second Amendment text history and tradition test that's got all of that working together. Justice Barrett said there's some open questions about how to do it. How do you see kind of this working together? It seems like on one hand, text history and tradition is very well established in a lot of areas of the Constitution but there's a lot of debate about, well, what is tradition? Whose tradition?
Yeah, and I think that worries originalists. You want to be certain before you incorporate something into how you're going to figure something out. And so if tradition is going to be employed, what is it, whose is it? And I think there's a lot of interesting papers now in the academy, and Sharif Girgis has got a new one coming out that I haven't had the opportunity to read yet, but I know it's anything Sharif writes is going to be really thoughtful, and I think there's a lot of those papers you yourself have written on this, and others have written on it. There's a professor at St. John's, I'm sorry.
Mark DiGirolamo.
Who writes a lot on it. And I'm glad you did it, because I've butchered his name before, and then people have made fun of me for it, so I'll let you do it.
All good, all good. So. No, I think it might be a good opportunity for us to pivot to audience questions. So if you would please raising your hand. A microphone will be handed to you, and when the microphone is handed to you, then you may ask your question. Please begin by announcing your name, and please have your question end with a question mark. Yes.
I'm Jonathan Mylander. Thank you very much for coming to speak to us today. I was wondering about the comments about the cognoscenti, which are at first import just a bit startling, because the legal profession is by its very nature always going to be something of an elite profession. And the Constitution itself was in some respects the product of an aristocracy, even if it's a lawyerly and Tocquevillian one. So I'm wondering what, either in your estimation or you think in Thomas's estimation, the proper role is for a kind of American aristocracy or elite today, especially with respect to the law.
Yeah, I mean, I don't. It's a great question. I don't know that there's a perfect answer to it. I don't think any one group or person should be treated differently than any other, no matter the status they may have achieved or not achieved. And so I think it's important as judges we interpret the law as it's written and not necessarily pay attention to what the elites or others are telling us the law should be, if that makes sense. And that's what he's saying more than anything else in my estimation. It doesn't mean lawyers, I'm not meaning to say lawyers don't have a say. Of course they do. They frame the arguments, they write the briefs, that lays everything in front of us. But I think it's important at the end of the day we do our job without regards to outside influences. And I think that's the way he views the cognoscenti.
Yes, sir.
I'm Gerald Chandler. My question is related to Kelo, but
I'm sorry?
To the Kelo case.
Kelo.
And the question is, what, if anything, does the Constitution say about socialism? And for example, could we nationalize General Motors? And if we could nationalize General Motors, how does that relate to Kelo?
Yeah, I mean I'm not going to give you an advisory opinion on that. I think it's a brilliant question in a way, which is, let me rephrase it and you tell me if I'm thinking about your question right, which is, could you, for the public use, take General Motors and pay the shareholders just compensation? And I don't know, is that the natural implication of the Kelo case? It's an interesting question, one hopefully I'll never have to face is the way I'm going to try to get out of it, but answering it. But I think it is an interesting and open question at this point. I would think, go ahead.
I don't have the microphone.
I can repeat what you say if you would like. Or there it is.
Okay. So I don't want to take the floor too much, but I want to just avoid the Kelo question, except for to ask, is there an implication? The question is there anything in the Constitution that prohibits socialism? If there's nothing in the Constitution that prohibits socialism, then I suppose we can have socialism, and I suppose that we could nationalize General Motors or NBC or anything else.
Yeah, I would say the one thing I would point to without answering the General Motors question is that the structure of government, I think, so Articles 1, 2, and 3 in some sense would prohibit socialism as we understand it today, at least in like China or something, or North Korea or Cuba.
Could I follow on? Many cities run trash collections in airports and other things, and I would call that socialism, and there's nothing in the Constitution that prohibits that, I suppose.
Well, remember, the structure of government only relates to the federal government.
Ed, did you have a question? Okay, go ahead.
Ed Whalen. Judge Thapar, could you talk a little bit about the role that originalism plays for you as an appellate judge? You're obviously dealing with lots of matters where there's Supreme Court precedent that governs you. At the same time, you obviously have an interest in exploring what the original meaning is, and how do you navigate that tension?
Yeah, it's a great question. I think, most of what we have to remember as an original matter that we are, by definition, an inferior court, which means there's a superior court, which is the Supreme Court. And we are bound by everything they do. And so stare decisis, vertical stare decisis is very important for lower court judges. And I think one area where we can start to think about it is we have to apply that precedent. But we can do separate writings if we see things kind of getting away from the original meaning that can't be binding. And so what happens is, if the briefs don't raise an originalist argument, if they do, you have to address it. And so the briefs confine what lower court judges can do, as does the Supreme Court. So in a majority opinion, you can never stray from stare decisis, but in a separate writing, you can start to lay out why you believe the law has gotten astray from the original meaning, or, for example, the law has, if you're looking at the text, the law has gotten astray from the text. And I've taken an opportunity to do that when I think I'm pretty close to being right. It doesn't mean I'm right. It doesn't mean I wouldn't revisit it with more thorough briefing, but it does mean that I would flag an issue. But I'm very careful always to do that in a separate writing that has no precedential value.
Adam.
Adam White, AEI. I got to read the book and I enjoyed it a lot. I highly recommend it. There is a pair of cases in the middle of the book, and I thought the pairing of them was fascinating, back to back. They both come out of the city of Chicago. First is a famous case, McDonald versus City of Chicago, where the court recognizes that the Second Amendment applies to cities and states through the 14th Amendment. And you tell the story of the case, and then you explain Justice Thomas's opinion and how he roots the origins of the 14th Amendment in, among other things, the need for newly freed blacks to be able to protect themselves in the aftermath of the Civil War. And then the chapter either right before or after it is a case I think also involving Chicago. I can't remember the name of it, Morales maybe.
Morales.
Right, and it was the case where there was a city ordinance for dispersing gangs from loitering to prevent gang violence in the streets. And Justice Thomas, you tell the story of that case and Justice Thomas' opinion. My point is, the McDonald chapter is titled Sheriff Cropper's Son. The other one is called, I think maybe Streets of Violence?
Streets of Terror.
Streets of Terror. I read that and I thought a progressive would read that pair of chapters and say, no, you actually mistitled the chapters. Maybe the case about the dispersion of gangs, maybe that's or maybe McDonald is the Streets of Violence case. And maybe the story there is that the city of Chicago should have been allowed for the people to take collective action to protect themselves. That's how a progressive would read that case. How do you think about that pair of cases, and how should people who are looking for judicial empathy and for the stories of the powerful versus the vulnerable, how should they think about that interesting pair of cases in the middle?
Yeah, I think so. I think if I remember correctly, Chapter 8 is Morales and Chapter 9 is McDonald. And I think because they were close in time as well, it was really interesting. And so Otis McDonald, maybe I'll tell both stories through the eyes of Otis McDonald. Otis McDonald moves north from Louisiana at a young age to pursue a better life, and he moves to Chicago. And he enlists in the military and serves his country honorably, gets out of the military and becomes a janitor, and at night on the GI Bill goes to college. And he gets a degree, and he wants to provide his kids and family a better opportunity than he had himself. And so he moves to the town of Morgan Park, which is a community at the time, a very nice community on the south side of Chicago. At the same time, as he moves out there to get away from violence and drugs and everything else, it starts to creep into his neighborhood. And his family, and you can read the chapter, but they suffer 6 different crimes. And Otis tries all sorts of things. First, to stop the crime. First, he puts bars on his house. When that doesn't work, he gets an alarm system. When that doesn't work, he joins a community group. When that doesn't work, he becomes the head of the community group, working with the police. One night, an eagle-eyed neighbor, I think it was the 6th crime they suffered, discovers a person, sees a person hiding under his car, and calls the police. And Otis says that's the last straw. Had they gotten in and no one noticed him, it'd be too late before he called 911 for his family, potentially. So he wanted a pistol at his side. At the same time all this was happening, around the same time, gangs were taking over the south side of Chicago. And people were living in terror. And the chapter recounts the testimony of the people living in these communities that just want to walk the streets and are afraid to walk the streets. And it talks about the kids and what they were writing in their papers about how it looks nice outside and I wish I could go outside. And it talks about the 52 children that were caught basically in gang crossfire and died under the age of 14. And so the city of Chicago passed an ordinance to ban gangs from loitering. And it didn't mean that they would be arrested for loitering. They had to loiter with other gang members, and then the police had to order them to be dispersed. These pair of cases go to the Supreme Court. So Otis wants to possess a gun to protect his family and his house, and at the same time, or around the same time, the city of Chicago is trying to deal with the gang violence, and the statistics were pretty remarkable as to what happened when the loitering ordinance was in place. It goes all the way to the Supreme Court, a pair of cases, in slightly different time periods, but Otis wins his case, and Justice Thomas writes separately to recount the black codes and what was done, again quoting Frederick Douglass, and talking about how blacks would never be free until they could have had the right to possess a firearm, because what was happening in the South is they were dispossessing blacks of firearms. One of the purposes of the 14th Amendment's Privileges or Immunities Clause, as Justice Thomas recounts, was to restore blacks' ability to possess a firearm. So here you have the descendant of slaves championing the rights of the grandson of slaves and the right to possess a firearm. At the same time, you have this ordinance going up to the Supreme Court, and it gets struck down. And I think 2 things are important there. One is what Justice Scalia said, which is we often give up at times our liberty, like speed laws. You know, of course we could drive any speed we wanted to and have liberty to do that, but we agree for our own safety to have speed limits. Or helmet laws, Justice Scalia points to in his dissent. In Justice Thomas's dissent, he recounts what has happened to the people in Chicago. And it's the only time I block quote Justice Thomas, and I'm going to read a portion of it to you because I think it captures what he's trying to do. He goes through and he agrees with Justice Scalia, and he has a whole section on how there's no constitutional right to loiter. He takes on the plurality on that. And then he says, and I think they signed each other's opinions, but I think here's what he finishes with. Today, the court focuses extensively on the rights of gang members and their companions. It can safely do so. The people who will have to live with the consequences of today's opinion do not live in our neighborhoods. Rather, the people who will suffer from our lofty pronouncements are people like Miss Susan Mary Jackson, people who have seen their neighborhoods literally destroyed by gangs and violence and drugs. And he recounts in his opinion what happened to Susan Mary Jackson and other individuals. They are good, decent people who must struggle to overcome their desperate situation against all odds in order to raise their families, earn a living, and remain good citizens. By focusing on the imagined rights of the 2%, the court today has denied our most vulnerable citizens the very thing that Justice Stevens elevates above all else, the freedom of movement, and that is a shame. And I thought those words were particularly powerful because they capture everything I'm trying to capture in the book. They capture the getting away from the original meaning has consequences. They capture creating things that don't exist have consequences. And they often have consequences, to quote Justice Thomas, for the most vulnerable citizens.
Yes, back in the back.
Thank you for waiting for the mic. It's easier.
Thank you, Judge. I apologize that I haven't read the book yet.
That's
although
okay.
I'm going to, because I live a few blocks from Morgan Park, just south of the city, so we have our own police force, so we live in slightly less terror than you're describing. So, Judge, I was wondering if you could speak on the history and tradition test in Bruin, since we're discussing the Second Amendment jurisprudence. I think I didn't get a clerkship because I liked it recently, so I was hoping you might have something to say about it. Thank you.
Yeah, no, so I don't want to speak too much to it because I think we're, as lower courts, still trying to figure it out, and the court's taken some cases to clarify exactly what they meant in Bruin in history and tradition. Here, I think they just took the Rohini case, and I can't obviously comment on a pending case. What I would say is in McDonald was slightly different, right? Because it was a question about, just so I'm clear, it was a question about incorporation and how to incorporate, whether to incorporate first, and how to incorporate the Second Amendment. And so in McDonald, they were talking about substantive due process versus privileges or immunities of citizenship, at least the plurality and then Justice Thomas. Whereas in Bruin, what Justice Thomas laid out there, as you've so eloquently pointed out, is a history and tradition test. And I think as lower courts, right, we're still working through this, as you've seen recently, and I think it's important that we, again, when we address cases or controversies, not to get too off topic, but we are confined by what is raised and the arguments raised in the briefs. And so it's important we not kind of just spout off on issues without seeing how the parties frame the issue, what history and tradition they bring to us, and how it fits into the puzzle of the overall case. So sorry not to answer your question directly. I'm sure your answer to whatever interview you did was brilliant, but
Yes.
Is there any issue where you disagree with Justice Thomas on something?
you know, I think there are cases where I'm not certain he got the better of the argument. One that strikes me that's really interesting is a case called Hamdi. If you read Justice Scalia's opinion in that case, he has a lot of originalist sources. Now, I understand where Justice Thomas is coming from there, right? I think he has more of a belief in the unitary executive, but Justice Scalia, look at his history in Hamdi. It's really fascinating. And I think that's really an interesting case. It's one I didn't put in the book, but in hindsight, I wish I would have. I would have studied it more and put that in. Like if I was going to do, every day I think about, okay, what would be the next chapter? I think Hamdi is fascinating, but I think it's much more fascinating not from a story perspective, although the story is interesting. I think it's from a historical perspective. It's a fascinating debate between Justice Scalia and Justice Thomas. So just to give a little story, I used to teach with this, maybe one of my favorite 5 professors in the world, Lillian Bevere. And we taught a class called Scalia versus Thomas. And in there it was, it's just so much fun when the two of them would disagree because their opinions are really interesting. And I think in there, when you're reading them, it's really hard sometimes to decide who's right just reading their opinions. You really need to dive into the sources. So before I committed that Justice Thomas is wrong in Hamdi, I would want to dive into the sources. But I can tell you that Justice Scalia had a lot more sources in that case. And that's what struck me, at least at first blush.
Judge Thapar, I'd like to maybe ask our final question is, when Justice Thomas was interviewed about his memoir, Grandfather's Son, I think he jokingly referred to being sentenced to a book contract. And just, given that your day job is writing, and maybe your overnight job was now writing too, Just reflecting on what it's like to be an appellate judge writing a book, would it be something you'd do again? Any advice for the aspiring? Or maybe advertise a trap for the unwary?
I don't know. My family, meaning my extended family, my kids, my wife, all my law clerks may all want to kill me if I engage in this again, because I'm up early, sleeping late when you're doing it, spending every weekend working on it. I would travel with my youngest son, and when he played sports, and watch none of the sports. I'd go find a library and write. And so I think it's really hard to do. I figured out that 3 to 7 in the morning is a very valuable time. Sometimes I drive my clerks crazy texting them questions in cases now, because I'm still waking up that early in between 3 and 7, but I try my best. I've refrained from picking up my phone at those hours and instead just worked on my own. But you know, it was interesting to work on a book. Luckily, it's in an area I'm passionate about. It's in an area I care about. It was always a goal of mine. As you know, I just think we lost so much more than a great originalist when we lost Justice Scalia. We really lost our evangelist for originalism, and I think a lot of us have to, not one of us can assume that mantle, but a lot of us have to collectively kind of pick it up. And I thought if I could take it to the lay people, maybe, you know, he'd look down on me and smile. I don't know, but I'm hoping.
Well, thank you for flying the flag and giving it to the people. 2 goals Justice Scalia would have surely liked, I think. Thank you very much, Judge Thapar.
Thank you.